All rise.
The Kosovo Specialist Chambers is now in session.
Please be seated.
Good afternoon, everyone, in and outside the courtroom. Madam Court Officer, can you please call the case?
Good afternoon, Your Honor. This is KSC BC 2020-06. The Specialist Prosecutor versus Hashim Thaci, Kadri Veseli, Recep Selimi, and Jakub Krasniqi.
Thank you, Madam Court Officer. Now I would kindly ask the parties and participants to introduce themselves, starting with the Specialist Prosecutor's Office. Mr. Prosecutor.
Good afternoon, Your Honor, and everybody attending and watching today. The Specialist Prosecutor's Office today is represented by Specialist Prosecutor Jack Smith, Marleen Yaya Hage, Legal and Disclosure Officer, and I am Wart Ferdinandersen, Head of Investigations and Prosecutions.
Thank you, Mr. Prosecutor. Now I turn to the defense, please. Mr. Kihu.
Good afternoon, Your Honor. Good to see you. Gregory Kehoe, Mr. Luka Misetic, Pierre Prosper, Sophie Manganol, Dosted Palaska, and Chiara Loyero on behalf of Mr. Hashim Thaci. Thank you.
Thank you, Mr. Kihu. Mr. Emerson, please.
Good afternoon, Your Honor, everybody inside and outside the courtroom. This is Ben Emerson representing Kadri Veseli together today with my co-counsel, Mr. Andrew Strong and Ms. Annie O'Reilly, and our legal assistant, Pascal Longley.
Thank you, Mr. Emerson. Mr. Young, please.
Good afternoon, Your Honours. Today I'm representing Mr. Selimi, and I'm assisted today in the courtroom by Mr. Roberts, co-counsel, and Ms. Reschenko, case manager. And Your Honour, on their first appearance in the courtroom, I'm also assisted, I believe, by team members Ms. Riva Jeshi and Ms. Sierra Skendo. Thank you.
Thank you, Mr. Young. And now I turn to Ms. Lagendra, please.
Good morning.
Sorry, I see Mr. Bayesu asking for the floor. So,
Yes,
Mr. Bayesu, then.
Thank you, Your Honor. Good afternoon to you and to everyone in the courtroom. I am Victor Bayesu for Mr. Jakub Krasniqi. By video link today we have Ms. Venkateswari Alejandra, lead counsel, Mr. Aidan Ellis, co-counsel, and Mentor Bechiri, legal associate. And I'm assisted today in the courtroom by Ms. Laura Abia, our support team member. Thank you.
Thank you, Mr. Bayesu. Just for the status conference today, shall I address to you, Mr. Bayesu, first, or to Ms. Alejandra?
To me first, probably.
This is noted. Thank you, Mr. Bayesu.
Thank you.
Now let me turn to the counsel for victim. But before, I just want to note that Mr. Thaci, Mr. Veseli, Mr. Selimi, and Mr. Krasniqi are attending this status conference not physically in the courtroom, but via video conference. Now I turn to the counsel for victims. Mr. Laws, please.
Good afternoon to Your Honour and to everyone. Simon Laws, assigned counsel for the victims in this case.
Thank you very much, Mr. Laws. And now, finally, I turn to the registry, please.
Good afternoon, Your Honour. The registry has today Mr. Jonas Nielsen, Judicial Services Advisor, on my right, and also myself, Ralph Roach, Head of Judicial Services Division. Thank you.
Thank you very much, Mr. Roche. And for the record, I'm Nicholas Guillou, pre-trial judge for this case. On 2nd December 2021, I scheduled this 9 status conference. I asked the parties to provide written submissions if they so wished. On 10 December, the SPO and the 4 defense teams submitted their written observations. I thank these parties for their written submissions. The purpose of our hearing today is to review the status of the case and to discuss the topics in our agenda, specifically disclosure, translations, SPO investigations, defense investigations, and detention. I will invite the parties to present their views in a concise fashion about each item. But before we start with our first topic, I would like to take time to remark on the conduct that I wish to see from counsel and prosecutors in this hearing and in future hearings. In the course of the last status conference, held on 29 October 2021, discussion between the parties sometimes devolved into personalized attacks, and it is not what I would expect of collegial and vigorous debate in the courtroom. I would therefore like to recall some principles as outlined in the Code of Professional Conduct for counsel and prosecutors before the KSC. Pursuant to Article 6.1c of this code, counsel and prosecutors shall act with respect towards anyone with a standing in the proceedings. In addition, Article 10a of this code provides that counsel and prosecutors shall act with due deference to panels. In light of these principles, I expect the parties to refrain from personalized or aggressive language directed at other parties or participants in these proceedings. Parties shall at all times demonstrate courtesy to the opposing party. Personal comments relating to and personal criticism of an opposing party shall not be tolerated. I would like to remind the parties that in case of non-compliance with these principles and obligation, I would not hesitate to resort to instruments that allow me to uphold order in the courtroom and ensure smooth conduct of the proceedings, including the measures under Rule 63 of the Rules of Procedure and Evidence. The objective of this and future status conferences is to provide a forum for constructive discussion so as to fairly and expeditiously proceed with the case, and I expect and encourage the parties to engage in such discussions. I would also like to remind and encourage the parties to be concise and not to repeat themselves in their submissions. This is of particular importance for this status conference, as we need to proceed through the items on our agenda before 6 p.m. at the latest, since, for the sake of the interpreters, they need some rest because they've been in this courtroom since the morning. I would like to thank the parties in advance for adhering to these principles and look forward to a constructive dialogue during this status conference. Before we go into matters pertaining to disclosure, which is the first item in our agenda, I would first like to address 3 issues raised by the defense in recent filings. The first is the time limit for the next detention review. The second is the Rule 149.2 notices provided by the defense. And the third is the matter that the Thaci defense requested, which is to be heard on matters relating to detention review and the submission of the SPO on contact with witnesses. So let's start with the first of these requests, which is the timeline for the next detention review. I note that the defense for Mr. Krasniqi, the defense for Mr. Veseli, and the defense for Mr. Selimi have requested a variation of existing time limits. In particular, it is requested that they be allowed to provide submissions within 10 days of a decision of the Court of Appeals on the third detention review. Do the parties wish to raise any further issues in relation to these matters? Mr. Kihu? briefly, please.
Yes, Your Honor. At this point, our appellate filing, I believe, has to be filed by December 27th, and we would ask for an extension until January 15th, given the holidays.
Thank you, Mr. Q. When you say January 15, it's January 15 to provide a position on this, or would it be for any?
I believe our appellate schedule has our appeal being filed shortly after Christmas and just prior to New Year's. And what we would like is, given the holidays, to extend that period of time out until January 15th.
This is not before me. This will have to be filed before the relevant panel.
That's fine, Judge.
I don't see any parties requesting to be heard on this matter. So I will now issue my first oral order on the timeline for the next detention review. In light of the defense requests, I consider that the parties' submissions on detention would benefit from analysis of the impending decisions of the Court of Appeals on the various accused appeals of my last decisions on detention. In this context, I note that Mr. Krasniqi, Mr. Vesely, and Mr. Selimi have waived their right to have their detention reviewed before the expiry of the 2 months time limit set out in Article 41.10 of the law and Rule 57.2 of the rules. I accordingly find that good cause have been shown, warranting the requested extension of time. I therefore order each defense team to provide submissions on whether reasons for continued detention still exist by no later than 10 days after notification of the relevant decision of the Court of Appeals on their pending appeals against my last detention decision. Responses and replies shall follow the timelines set out in Rule 76 of the rules. Should the defense for Mr. Krasniqi, Mr. Vesely, and Mr. Selimi decide not to file any submissions, the SPO shall file their submissions by no later than 10 days after the defense deadlines. If the defense wishes to respond to the SPO's submissions, then they may do so 10 days after the SPO's deadline. This concludes my first oral order.
If I may, Your Honor, given the fact that our decision just came down literally this morning, we certainly would want to be incorporated into that extended timeline after the appellate review, whenever that decision might be. So we would make that oral submission at this time.
Thank you, Mr. Kihu. This is noted. I will then issue a written decision as soon as you have filed your appeal. I will wait for the appeal to be filed. But your position is noted in any case, and your request is noted. Now, in relation to the SPO's disclosure of expert reports, I note that all defense teams have indicated in their written filings their intent to challenge the qualifications of the SPO's expert witnesses, not accept the expert witness reports, and cross-examine these witnesses. The defense teams also reserve their rights to file updated notices pursuant to Rule 149.2 of the rules. In light of the parties' submissions, I formally take note of the defense Rule 149.2 notices. These notices and any updated notices will be included in my handover document to the trial panel, so the trial panel can take these matters into consideration when determining the witness expert status or the admissibility of the expert witness reports pursuant to Rule 149.4 of the rules. Do the parties wish to make any further submission on this matter?
No, Your Honor.
No, Your Honor.
Thank you very much. Now, in relation to the Thaci's defense request to address additional matters at this status conference, I note that we have a very limited time to get through a number of agenda items. And I further note that with respect to the detention review, the issues raised have been addressed in the decision rendered yesterday. As regard the SPO's filing F594 concerning confidential information and contact with witnesses, I note that this filing was filed and distributed on 3 December 2021. Victim counsels responded on 10 December 2021, and the Thaci defense and the Salimi defense responded today. As I prefer to receive submissions on this matter in writing and do not wish to use our limited time today on this issue, I reject the Thaci defense request to be heard orally on this matter. At today's hearing, I will assess the need for further debate on this at a further hearing when I will review all the submissions that will be filed in writing. Let us now move to the first topic that was listed in the scheduling order, which is disclosure.
Yes, Your Honor, may I just discuss the two items that you have spoken about. Having the opportunity to address orally the disclosure or treating of witnesses, we feel that, and as we have submitted, that that we strongly suggest that the court hold a hearing on those items. As we put forth in our filing, the incursion into the defense camp is unprecedented, certainly in my career and in the career of my colleagues. So the position presented by the SPO at this point would essentially vitiate the defense and bring them all into the defense camp. Where am I going with this, Judge? If the court is considering these measures, we ask very, very strenuously that the court engage in an ongoing open discussion in the courtroom as to how these issues are going to be handled. Because the way that the prosecution has presented this would cut the legs off, if you will, pardon my vernacular, of the defense or the ability to put together a defense, would allow the prosecution into the defense camp, would violate the attorney-client privilege, et cetera, and would violate our respective clients' rights. So I understand that Your Honor is not going to make a decision on that point now until Your Honor has all of the written filings in this matter. But once the court does, we strongly suggest that Your Honor conduct a hearing. On the first point, I understand that Your Honor has made a decision on pretrial detention this morning, and that matter will be appealed. However, there is a regime where we're going to be back before you in very short order if your decision is in fact affirmed. And one of the things that we wanted to discuss with the court at this point are the parameters of pretrial release, what more the court would need. We haven't had an examination of anybody from the Kosovo police or from third-party countries. The only thing we have had is submissions by the prosecution talking about the police in Kosovo being corrupt. You can't rely on them. They are the worst organizations in Kosovo and can't be trusted to follow Your Honor's orders. Those discussions need to be addressed in a public forum and have the prosecution question representatives from the Kosovo police or representatives from third-party countries and ask the questions that need to be asked in order to satisfy you, Your Honor, that the protective measures are in place to ensure that these four gentlemen will not violate the law, will abide by Your Honor's rulings, and will return to this chamber as ordered. That is, I don't seek at this point to revisit Your Honor's order. What I seek to talk about is guidance on what more we need, given the fact, as I presented, that no Kosovar Albanians have ever been released from this court. They did it in the ICTY, both Serbs and Kosovar Albanians. No Kosovar Albanian has been released on pretrial release by this court. Why? Why? Are there no conditions present at any time that would guarantee that these individuals would present themselves to the court at the proper time, would abide by Your Honor's law restrictions, and would abide by any other limitations that Your Honor put forth. That proceeding, again in open court, as with the confidential witness proceeding, has to be addressed in open court so we can hear in open court what the prosecutor's reservations are about the Kosovo police or any other entity. So again, it's a request for a public hearing to address reasons how we can ensure that these gentlemen, as they're awaiting trial, as they have for the past year, can go back home and also abide by Your Honor's orders. Do what Your Honor wants them to do when they're at home, as opposed to this veiled comments by the prosecution that they want to hide behind confidentiality orders about how the Kosovo police are corrupt and can't be trusted. We need an examination before Your Honor, where Your Honor and the prosecution and everybody else can question these individuals to ensure that they are going to abide by what Your Honor orders, which is the key. And that's what we're asking for in this. I don't mean to revisit your decision that you made this morning, but given the fact that we're on a pretty short timetable, where we could very well be back before you in the same exercise for pretrial release, we wanted to put forth what the defense needs to advance this position and explain it thoroughly to the court, as opposed to this rumor and innuendo and unsupported allegations made by the prosecution.
Thank you, Mr. Kiyu. Mr. Prosecutor, very briefly on this matter, because this is not in the agenda, please.
I can be very brief, Your Honor. Thank you. The Thaci defense has just mischaracterized SPO submissions in a way that would be problematic in any status conference, but especially so after you have indicated that this is not an issue to be addressed today, so there will be no chance to respond in any sort of time. Thank you.
Thank you. Let us now move back to disclosure. I will give the floor to the parties on the disclosure of each evidentiary material separately, as we did in the previous status conference. The Rule 121B material, which is the evidentiary material the SPO intends to use at trial. The Rule 1023 material, which is the material relevant to the case as listed by the SPO. The Rule 103 material, which is exculpatory material, and the Rule 107 material, which is protected material for which the consent of the provider is requested. So let us start with the disclosure of Rule 121B material. At the last status conference, I extended the deadline for the disclosure of outstanding 121B material and the translation of such material to 31st of January 2022. On 5 and 17 November 2021, I issued decisions on the SPO's 11th and 12th requests for protective measures. In its written submissions, the SPO indicated that since the last status conference, it has disclosed a total of 5 new Rule 121B items, all comprising material related to the 11th and 12th protective measures requests. The SPO has also disclosed 2 packages containing translations of Rule 121B material. I also note that the SPO does not foresee difficulty in meeting the 31st of January 2022 deadline for the disclosure of remaining 121B items, including translations. I would like to hear from the parties what progress has been made in relation to the disclosure of Rule 121B material. In particular, I would like the SPO to indicate precisely how much of such material remain to be disclosed and what are the outstanding Rule 121B material to be disclosed. I would also like the parties to give their feedback on the new witness entities that have been created in legal workflow following my oral order in the last status conference. I note that the defense indicated in its written submissions that despite the creation of witness entities, searching for witness material remain insufficient. The Selimi defense notes in particular that very limited information has been populated into legal workflow by the SPO in relation to each entity and requests to add the following information. First, all previous statements of witnesses disclosed under Rule 102.1b in whatever form, including transcripts of prior proceedings, SPO interviews, statements and interviews or public statements given in any form. Second, all documents about a particular witness prepared by investigative authorities, including but not limited to the SPO, such as investigators' notes and memos. Third, all exhibits shown to a witness during interviews. And fourth, any filing and submissions directly relevant to these witnesses, including but not limited to protective measures or mode of testimony. The Salimi defense also suggests that legal workflow is set up to link more information in the future to each entity. Notably, the proposed exhibits by use of the presentation queue for each entity, proofing notes, and transcripts of each witness testimony. Finally, I note from the Salimi defense submissions that no information has been provided by the SPO on either the review of documents linked to Mr. Salimi or the efforts it has undertaken to link translations, lesser redacted versions, and corrected versions of documents of their originals in legal workflow. Sorry for being a bit long, but I invite the party now to give an update on these issues and other similar problems that they may face regarding the categorization and linkage of items in legal workflow. And I will first give the floor to the prosecution. Mr. Prosecutor.
Thank you, Your Honor. In addition to the 102.1b releases you have mentioned, one further package of Rule 102.1b materials was disclosed this week, containing 13 items recently received from a third-party institution. Of the over 11,300 Rule 102.1b items which have been disclosed, disclosure of English translations of approximately 496 items remain outstanding. Of the over 1,400 Rule 102.1b statements which have been disclosed, disclosure of Albanian translations of approximately 545 items remain outstanding. All requests for variation of protective measures which were outstanding before third-party institutions have now been granted. The SPO has received most of the materials in question and is processing them for disclosure, which we anticipate completing before the end of January. There is only one 102.1b item remaining for which Rule 107 clearance is still awaited.
Sorry to interrupt you, but I see that the connection with the accused have been suspended, so I will wait until the connection is remade. Madam Court Officer, when you can, if you can give an update to the court. So I'm informed that the audiovisual technicians need at least 10 minutes to reconnect. So we have two options. Either we proceed without the accused on the line, or we wait for these 10 minutes for the connection to be reestablished. I have a preference to wait for the connection to be reestablished, unless the defense teams wish me to proceed, but I would rather take a break for 10-15 minutes.
Your Honor, we certainly can't waive without talking to our clients, so we would ask for a delay of 10 to 15 minutes.
No, I agree.
When you say you want me to have a break for 10-15 minutes so that it's reestablished, correct? This is not it. So we're going to have a short break of, let's say, 10 minutes, hopefully 10 minutes, and we will come back in court as soon as the connection is reestablished. The hearing is adjourned.
All rise. All rise. Please be seated.
Thank you. I see that the connection has been reestablished. Mr. Thaci, Mr. Vesely, Mr. Selimi, Mr. Krasniki, I apologize for this technical interruption. We'll ask the Specialist Prosecutor's Office to start from the beginning of its last submissions, because I think this is where the connection has been lost, and I wouldn't want that you are not privy to everything that has been said during this hearing. So I give back the floor to Mr. Prosecutor. Thank you.
Thank you, Your Honor. In addition to the disclosures mentioned by you in your introduction, one further package of Rule 1021B materials was disclosed this week, containing 13 items recently received from a third-party institution. And of the over 11,300 Rule 1021B items which have been disclosed, disclosure of English translations of approximately 496 items remains outstanding. Of the over 1,400 Rule 1021B statements which have been disclosed, disclosure of Albanian translations of approximately 545 items remains outstanding. All requests for variation of protective measures which were outstanding before third-party institutions have now been granted. The SPO has received most of the materials in question and is processing them for disclosure, which we anticipate completing before the end of January. There is only one 1021B item remaining for which Rule 107 clearance is still awaited. And as previously indicated, that is one associated exhibit of an international witness. As mentioned by you in your introduction, the SPO is on track to meet the deadline of the 31st of January 2022 for disclosure of remaining Rule 1021B items, including translations. On 29 October, Your Honor ordered the SPO to create witness entities in legal workflow to link prior statements and associated exhibits to the relevant witness by December 15, 2021. And as was discussed at the previous status conference, there were some technical difficulties encountered in creating the witness entities. The functionality in legal workflow for releasing linkages between batches of witnesses and their associated materials became available for testing on the 1st of December, and it was implemented in legal workflow on the 7th of December. The witness entities have been created, and relevant relations to evidentiary items have then been made. We have conducted careful checks to ensure that material which may be identifying for delayed disclosure witnesses is not linked, and there are some technical challenges that have affected both the creation of the witness entities and their performance, including the appearance of witness index numbers noted by the Selimi defense. We continue to work with the registry to solve them. Despite those challenges, 268 witness entities have been released, and if the technical challenges can be met, we anticipate releasing the last entities later today. The SPO is currently finalizing the review of all items categorized in relation to Mr. Selimi, and we will soon revert to the Selimi defense on the results of that review inter partes. The SPO has also conducted a review of the linking and metadata of translations, lesser redacted versions and corrected versions, and is continuing to do so. The SPO has fixed missing relationships of translations and metadata where technically possible and will continue to do so. And when this was not possible, the SPO has informed the registry for their assistance and will continue to follow up. While some clerical errors have been identified and solved, there are also some technical challenges regarding legal workflow that have affected the SPO's review. And constructive discussions on a technical level regarding all these issues will be the best way forward. And like the Selimi defense, the SPO is open to further inter partes discussions regarding all disclosure matters, and these can likely be discussed at the envisaged legal workflow forum meeting. As previously indicated, the SPO will gladly participate in such a legal workflow working forum. Unfortunately, the Salimi Defence's submissions mischaracterize its communication with the SPO about this matter. We query why defense teams would wait until 7 December to unilaterally demand a meeting with the SPO at a 2-day notice without involving the registry, while at the same time apparently a separate meeting between the Krasniqi defense and the registry regarding legal workflow issues was being organized. We believe that a legal workflow working forum will work particularly well when it involves all parties, is organized constructively and with fair notice to everyone involved, and respects the registry's leadership when it comes to technical legal workflow issues. We look forward to leave these apparent misunderstandings behind us and cooperate in a constructive manner with all parties involved. We have noted the registry's response that it supports this approach and stands ready to provide input and assistance on technical issues regarding legal workflow. We highly appreciate that, as we believe that will be important to move this process forward, and we look forward to a constructive dialogue in January. Thank you, Your Honor.
Thank you, Mr. Prosecutor. Just one follow-up question regarding the list of information that the Salimi defense suggests to include in each witness entity. I understand that at the moment there are some technical difficulties that should be fixed in the following weeks, but do you oppose any of the type of information that is listed in the Salimi submissions that I just recalled before I gave you the floor? Or are you in agreement with all of them, but it's just a question of technical difficulty at the moment?
We are not in agreement with everything listed by the Salimi defense. The Salimi defense has now raised additional demands regarding the way they believe information already in the possession of defense teams should be reflected in legal workflow. Your order for the creation of witness entities was made in response to the Salimi request that the SPO should create witness entities and link the requisite associated exhibits to each entity. And according to the Salimi defense, that would be minimal additional work for the SPO. That is what has been done, as agreed and ordered. We are open to exploring the new issues raised by the Salimi defense. The SPO is committed to make available all relevant information to the defense through legal workflow and is willing to see if it can support in an efficient manner defense wishes to carry over that information from legal workflow to other working platforms. But the SPO sees no grounds for the kind of unilateral demands now formulated by the Salimi defense. In addition, it may be queried whether it's appropriate security-wise and a proper use of resources to request the SPO to duplicate in the witness entities information about witnesses that is already available to the defense. Like the Salimi defense, the SPO is open to further inter partes discussions regarding such more detailed matters, and these can be likely be discussed at the envisaged legal workflow forum. Thank you.
Thank you for the clarification. Mr. Kihu, please.
Yes, Your Honor. Just a few brief points. I'm always intrigued by the prosecution saying that the defense is something less than diligent in providing matters in a timely manner. Just for the record, one matter left out by my learned friend across the bar was that almost half the documents that they provided since the October 29th hearing came within the last 48 hours. So the diligence on disclosing 102 or 1B material seems to be less than aggressive on behalf of our learned friends. That being said, I turn our most important question back to the question that Your Honor asked in your outline for this hearing, which is, how much is left? Your Honor asked that question, and that question hasn't been answered. We're looking at 102, 1B material that we've been looking at for over a year. How much more is coming? And I'm not talking about the 107 restrictions that they're awaiting for one witness, apparently. But how much is coming across the transom? We had another 899 documents since October 29th. So what's left to be turned over? And that, Your Honor rightly asked that question in your outline in paragraph 1A, and I submit to Your Honor that the court, as well as the defense, deserves an answer to that. Now, with regard to the legal workflow, I'm going to let my friends on the Salimi defense talk about that at some length because they're much smarter than I am. But that being said, I will tell you that in my review of the legal workflow, which the court ordered on the 29th of October that it be done, I I don't want to put words in your mouth, but the intent certainly was expeditiously. It looks like very little was done until the early part of December. And right now, the legal workflow documents that I reviewed with the assistance of my colleagues is deficient almost across the board. Yes, they have some numbers in there, but all the other requisite information that you would need in order to make this a functional piece for moving this case along is gone. Query, what was the prosecution doing from 29 October until, I guess, the 2nd of December? But with regard to the specifics of legal workflow, I'll turn to my colleagues on the Salemi defense to give some more details about that.
Thank you, Mr. Kihu. Mr. Emerson, please.
On a general level, we've noted in our written submissions that so far we've had, it's obviously a little more than that now because there's a couple of days have passed, 13,800 items labelled under Rule 1021B, of which more than 11,000 post-date the 23rd of July deadline, and one can hear as well about the increased volume just before this status conference. Again, I suppose I would echo the comment made by Mr. Kehoe that we obviously need to know how much more there is and what it is in broad terms, and to have some idea of how much more to expect. I mean, are we to expect a huge volume of material, a glut in January, or not? That would be a helpful indication. But overall, and I'm going to leave my co-counsel to deal with certain specifics, I'll go through them in a minute. Overall, I would like to simply lay down the marker that if you look at the timeline for the way in which the prosecution has served its evidence and the length of its proposed pre-trial brief and the number of witnesses that are going to require to be called at trial on the current witness list, I have to be frank, we haven't and won't have until sometime into the new year, probably some considerable time into the new year, have even done a first read-through of everything. So that is the reality of the situation that we all now find ourselves in. I'm going to, if I may, defer to Mr. Strong to deal with witness entities and the Rule 103 issues, and to Ms. O'Reilly to deal with 1023 material.
Mr. Strong, please, on the witness entities. We'll address the 1023 later. Mr. Strong, please.
Excellent. Thank you. Just with respect to the witness entities, I want to emphasize that we see this as a fundamental piece of the information infrastructure in this case. As Your Honor knows, up until this point, the way the disclosure has been carried out is such that as you're reading through a witness, if there's a document that's described by the witness or used with that witness, you need to search across the entire sea of disclosure to find it. And if it doesn't have an ERN attached to it, it's effectively lost. So for the first time now we're able to gather all of these documents in one place, and that is only, so that's such a welcome development, but it's only useful if it can be used. And so to have a witness with 10 documents that are just identified by an ERN and not a description or a name isn't particularly helpful. It still requires considerable time. The only other point to make on this is that because this is happening now at this stage of the proceeding, the defense is in a position where we're now having to revisit the witnesses that we've already read to read them in context with the documents that they're associated with. And with a case where there's 60 or 70 witnesses, that's a cumbersome task. But in this case, where there's 330 witnesses, that is going to have knock-on effects in terms of the defense's timeline and preparation. And so I want to make sure that that's put down. Thank you.
Thank you, Mr. Strong. Mr. Strong, do you want to add anything? Thank you. Mr. Young, please.
Your Honour, thank you. Well, first of all, before I turn to legal workflow, because there's a lot to discuss in relation to that, let me deal with a matter raised in relation to paragraph 5 of our written submissions. I think Your Honour referred to them earlier, where you drew attention to the fact we indicated there was no information had been provided by the SPO on either the review of documents linked to Mr. Salimi or the efforts it's undertaken on translations, lesser redacted versions, and so on. Just to be complete, that was written on the 10th of December. Yesterday, we received an email from the prosecution, so it's right to say they have now responded, and we will consider their response carefully. Turning to the main issue, Your Honour, in relation to legal workflow and the matters we raise at paragraph 22 of our written submissions, and Your Honour read them out, so I don't repeat them. But basically, we submit these are obvious and sensible case management proposals, these are very, very obvious and evident requests for better case management. What the prosecution appear to be saying is, they seem to be saying that they might accept some of our proposals, but not others. I'm not clear, to be honest, what they're saying in terms of whether they're prepared to link statements, but not transcripts, interviews, but not expert notes or filings. I think the position, Your Honour, is that the prosecution should respond now they've seen our filing and indicate what they are prepared to do and what they're not prepared to do so we can litigate it. But this is very important because, as Your Honour knows, in any witness package, normally the key ingredients of a witness package will be witnesses' prior statements, any prior transcripts of evidence, any reports and such like, and exhibits. So these are, with respect, all eminently sensible proposals, and I cannot see for the life of me any reason why the prosecution would object to that. Now, the other matter is, of course, this, that as I understand, as of today, there are now 268 witness packages. I have to confess I'm wholly unclear, and I don't think we've heard this from the prosecution, to what extent they say they have populated in legal workflow these 268 witness packages with prior witness statements, with prior transcripts, with prior reports, prior interviews. These are all fundamentally important to the defence. And so I do ask that the prosecutor make it clear to Your Honour today and to the rest of us, what have they done? Because from what I can see, he's really ducked that question wholesale. So if we can know that, that would be helpful. There's been no mischaracterization. The defence for Salimi have actively engaged with the prosecution and sought to assist them. As Your Honour knows, Mr. Roberts and I are quite familiar with legal workflow, or Your Honour may remember from a long time ago. It's not something that's magically appeared like TikTok in the last year or two. It's been around for over 10 years. It's been used by the international courts for over 10 years. So I fail to understand how, in a case with the high spec that the KSC has, how it is that only a few days ago, they started to organize the functionality of legal workflow when it's meant to be a core aspect of case preparation. I don't frankly understand that, but we will work with the prosecution. We will work with the registry to do anything we can. But our submissions are clear, they're on paper, they deserve a response, because these are very important for the way in which the court works, the expeditious way in which the court can work in the future. And it's important not just for the defense, but for the victims and for the prosecution. And if this is not started, as Mr. Roberts has said on previous occasions, if it's not fixed now, it's going to get a whole lot worse in the future. So I would really strongly endorse the prosecution to grasp the nettle and indicate what their problem is with our proposals, because in my respectful submission, they're all eminently sensible. Thank you.
Thank you, Mr. Young. This is why I recalled all your proposals in my introduction to this topic. Mr. Bayezu, please.
Thank you, Your Honor. Mr. Ellis will make our submissions covering this agenda item. Thank you.
Thank you. Mr. Ellis, please.
Thank you, Your Honour, and I will address all the issues on agenda item 1 as well in due course, Your Honour. Your Honour, there are a range of technical disclosure issues persisting in relation to legal workflow, much as we've outlined in previous status conferences. It had always been our intention that those be addressed between the parties at a forum at which the defence would attend, the SPO would attend, and a representative of the victims, of course, as well. I regret that hasn't happened before this status conference. It's, of course, something that you'll recall we've been proposing for some time, back as early as September, I believe. Nonetheless, I believe the intention is that it will happen in January, and I hope there'll be a more substantive update to give, Your Honour. And I very much encourage all parties to attend that forum in a constructive spirit and to grapple with the technical issues we are all facing. In relation to the specific issue of witness identities, I strongly endorse and support the suggestions made by the Salimi defence. We agree with those. Thus far, there's been no communication whatsoever as to exactly what the SPO is doing in relation to these witness entities. I've received, I think, 268 separate automatically generated emails telling me that a witness entity has been created, but no information whatsoever as to what that means, what exactly has been linked to those witnesses. Are those entities now said to be complete, or is there more work ongoing? Those are the answers that we seek. And thank you, Ron.
Thank you, Mr. Ellis. Let me give the floor back to the SPO, especially on 2 points that have been raised by the defense, and I think rightfully so. If I go back to the transcript, I think you mentioned the material to be disclosed, but you mentioned the translation that is remaining, not the material that remains to be disclosed. So I would like to have a specific and precise figure on the material that is left to be disclosed. And second, which I think we raised by Mr. Salimi, each out of the category, what has been populated so far in the witness entities? And is it just a start, or is it to be populated in the following weeks once the technical glitches will have been solved? Mr. Prosecutor.
Thank you, Your Honour. First, on the numbers of the Rule 102.1b disclosures, I note that the number of disclosed items mentioned by the Thaci defense are translations of previously disclosed Rule 102.1b materials, and the translation numbers have been indicated very precisely, as you said. And I believe that the numbers of 102.1b materials still to be disclosed, not being translations, are one-digit numbers. I don't have the exact number. But it is less than 10, I believe. When we are talking about the witness entities, I've indicated we are open to further discussions on these matters, and I believe that is the correct way to proceed with them for a number of reasons. First, the issues being discussed here are both of a technical nature and are of a question which party is feeding what information into legal workflow. It is quite certain that there are differences of opinion between the Salimi defense and possibly other defense teams and the SPO. However, I do believe that further discussions on a more detailed basis by the people who have most knowledge of legal workflow will be beneficial to diminish those differences of opinion, because I do believe that our positions have not been brought together as much as is possible. For example, redacted and revised versions are currently identifiable by way of their ERN, and transcriptions of SPO interviews are not translations in our view, and I believe that a further discussion, taking into account each other's points of view, will be beneficial to make sure that we only put before the Chamber differences in this regard that have been fully explored. I do note that the resources required to link lesser redacted and revised documents and as well as to populate witness entities with all possible information. Partly depend on the technical aspects of legal workflow, but it would in any case seriously diminish available resources for other disclosure work streams, and that would be done to duplicate information already available to the defense. Now, the SPO is willing to, with an open mind, discuss with the defense why it is that these requests are being made and what are possible alternatives. But at this stage, it does not seem to us to be the best use of SPO disclosure capacity. And we believe it will be beneficial to continue such discussions. Thank you.
Thank you, Mr. Prosecutor. If I may, before giving the floor to the defense, this issue of populating legal workflow for the witness entities is beneficial to the defense, certainly, but will also, at a certain point, will be beneficial for the trial panel. And so this is something that is to be taken into account for the future. Very briefly, Mr. Kehoe.
Just by way of clarity, Judge, with regard to 1021B documents, is it the position of the SPO that the number of documents to be disclosed is somewhere between 1 and 10? Is that what I'm saying? Is that what I'm hearing?
I think it's even between 1 and 9, because single digits
1 and
means
9.
1,
Single
0,
nines.
and 9. That's what I understood.
So we are not getting any, there are no more documents above a single digit amount that fall in the category of 1021B. Do I understand that correctly?
That's what I understood. We can go back to the transcript, but I think the prosecution said, I believe, so there is a small caveat, but that's also what I understood. I understood single digit, i.e. between 1 and 9. The figures that have been given by the SPO at the beginning of this item on the agenda was referring to the translations.
Yes, yes.
Mr. Prosecutor, do you wish to add anything on this?
Sorry, Your Honor. Indeed, I have given the precise number for the translations to be disclosed, and we were discussing other items than translations, and I fully agree to your definition of single-digit numbers. Thank you.
So I think that's clear. Thank you very much. I don't see anybody requesting the floor. Let me just invite the parties to continue their discussion on legal workflow. Mr. Young, please, briefly.
Yes, thank you, Your Honor. Very briefly, firstly, I don't believe that the prosecutor has responded to the matter that I raised with Your Honor, namely to give us some information as to his understanding of the level of population of the 268 witness packages in terms of the very obvious basic proposals we made in our paragraph 22. I don't believe the prosecutor's answered that in any way, shape or form. Secondly, the prosecutor appears to suggest that that it may not be the responsibility, at least that's how I interpreted it, it may not actually be the responsibility of the prosecutor, or there may be an issue over who feeds the information to legal workflow. With respect, that's quite an outrageous suggestion. I don't know if he's suggesting the registry staff should do this. As Your Honor knows, it's the prosecution who bring the case. They're responsible for presenting the case, and that includes presenting the evidence in a proper manner before the court and the trial panel. And this appears to be a suggestion of an utter abdication by them for resource difficulties, and that's really utterly unacceptable. And so my learned friend of the prosecution suggests, well, what are the alternatives? Let's sit down and discuss the alternatives. In my respectful submission, I can say this very clearly. There are no alternatives. These are very basic, obvious things, and the fairness of the proceedings will be significantly undermined if the prosecution do not state what they're prepared to do and populate the legal workflow as we've asked.
Thank you, Mr. Young. Mr. Prosecutor, do you want to add anything?
I will just add my invitation to discuss these things constructively on a technical level by the people who know most about the functioning of legal workflow. I note that the Salimi defense has indicated being open to do so in several emails to us, so I would suggest we do so. Thank you.
So I invite the parties to continue their discussions, but this matter will be reevaluated at the next status conference. And I invite the parties, especially the Selimi defense, to give an update in its submissions before the next status conference on this matter. And especially if there are categories that are not populated that you would like the SPO to populate in the future. Let us now move to the Rule 102.3 notice and evidentiary material. I remind the parties that at the last status conference, I suspended the remaining defense deadlines for Rule 102.3 material. Since then, the SPO has indicated that 3 Rule 102.3 disclosure packages have been released. I note that further packages have been disclosed yesterday evening on top of these ones. Regarding this disclosure timelines of Rule 102.3 material, the defense submit that no deadline should be re-established for requesting such material, as the defense will need to make further requests in the future. First, as a result of the significant number of witnesses for whom disclosure of their identity is delayed. And second, once the defense have had the opportunity to conduct more fulsome investigations. The defense considers that it shall have the ability to conduct further review of the Rule 102.3 notice and make further requests each time new information is received. The SPO indicated that given the multiplicity of concurrent requests, their varying size and complexity, and the need to compare and coordinate between the requests, there would be difficulty in ascribing deadlines to individual requests. I also note the Krasniki defense request that the SPO should be ordered to disclose the relevant Rule 102.3 material by 14 January 2022. And I further note the Selimi defense submissions regarding the overlap between Rule 107 material and Rule 102.3 material, and the potential need for a supplemental Rule 102.3 notice. I would like to hear the parties on the disclosure calendar of this Rule 102.3 material and more generally an update on the disclosure of this category of material. Mr. Prosecutor.
Thank you, Your Honor. As indicated in our written submissions, the SPO has continued to work actively on the processing of Rule 102.3 requests, and until this week, 8 packages have been released. The SPO anticipates releasing at least 4 more packages this week, and before the start of the judicial recess at the end of this week, more than 12,500 items relating to requests from each of the Krasniki, Selimi and Vaseli defense teams will have been released since the last status conference, and each defense team with outstanding requests will have received multiple and substantial packages.
Interpreters know the transcript in interpreter's booth has frozen.
The interpreter just mentioned that the transcript in the interpretation booth has frozen. So before we resume, I will ask the court officer to inform me if this has been resolved. This might involve rebooting the software. It might take a couple of seconds. I hope not minutes. I think we are now ready to start again. Can the interpreters confirm me in the headphone?
Yes, Your Honor, it has been resolved.
Prosecutor, sorry for the interruption. You can proceed.
Thank you, Your Honor. Rather than processing 102.3 requests in their entirety, strictly in the order as received, the SPO has proceeded to process various outstanding requests from different defense teams, aiming to disclose substantial packages to all defense teams with outstanding requests. In doing so, we have taken into account the time frame for the lifting of protective measures for witnesses this week. If we would have fully processed outstanding requests in the order received, that would have resulted not only in uneven disclosure to different teams, but also in unnecessary redaction and litigation to conform to protective measures being lifted a short time later. These are the reasons that for the second request of the Krasniqi defense team, some 75% has been disclosed in this period rather than everything, and we expect to disclose the remaining items of that request in January. Due to the number and sizes of the multiple 1023 requests of the different defense teams, there is still substantial work to be done for the SPO. We welcome the fact that a recent 1023 request of Krasniqi has been joined by the Salimi defense team, as joint requests are more efficient to process and can thus contribute to a faster completion of this procedure. Processing all outstanding 1023 requests is a priority for the SPO, and we are planning to commit considerable further resources to this work stream in the coming weeks, resulting in a substantial increase in the pace of review and processing. While 1023 packages will keep being disclosed on a rolling basis, we anticipate that this intensification will result in a high disclosure turnout, especially in February. For a number of reasons, it is difficult to set deadlines for individual requests. Not only do the requests vary greatly in number of items, the processing time for each item is also very different, depending on the public or sensitive nature of the document, its language and size, and its relation to other similar or related documents. Assessing the possible need for redactions cannot be done in isolation, but often requires review of a number of related documents, including ones already disclosed or being requested in other 1023 requests. It will benefit the efficiency of processing and avoid unnecessary litigation if we retain the flexibility to keep grouping similar and related sets of documents from various requests for review and processing and disclosing these on a rolling basis. Thus, the SPO requests to keep the deadline suspended until the next status conference in February. We will be able to report on the results of our further intensification of this work stream and more concretely forecast the resulting disclosures in February then. If there is also more clarity about the status and timeline of the Defense 1023 requests at the next status conference, a more concrete discussion of the time frame for processing the requests in their totality can be held then. Thank you.
Thank you, Mr. Prosecutor. Mr. Kihu, please.
Yes, remarkably, Judge, we have found common ground with regard to the suspension of any deadline for 1023 material at this point, Judge. We believe, as the prosecution does, that any deadline for that is premature, given all of the outstanding matters that have yet to be disclosed, witnesses, unredaction, the indictment, the multitude of issues that Your Honor knows about. So a suspension of that timeline, we agree, is warranted.
Thank you, Mr. Kihu. Mr. Emerson.
I'm going to ask Ms. O'Reilly to deal with this matter, if I may, simply recording by way of introduction that the defence have made requests for 16,270 items and have so far received 79. So whilst I entirely accept that it may be that the prosecution are going to devote greater resources to speeding up the process, at the moment it's barely got off the ground as far as we're concerned.
Thank you, Mr. Emerson. Ms. O'Reilly, please.
Thank you, Your Honour. Just a brief correction. So actually, so far we have received 1,736 as a result of last-minute disclosure dumps before the status conference. But yeah, it's still only at about 10% of what we've requested overall over the course of 9 separate requests. We are unaware of any particular protective measures requests that are outstanding in relation to this material. And we would note furthermore that we have no indication of when the rest of those documents will be disclosed, except that it now appears that will be at some point after the end of January when they're done with their pretrial brief material. We agree that there should be no deadline imposed on defence requests, as what is material to the defence obviously changes as we get a full oversight of this case, which we still have not been able to do as a consequence of the volume and pace of disclosure. So our submission is that the deadline will have to be suspended indefinitely for us. However, if the prosecution continues to disclose Rule 1023 material at this rate or anything comparable to it, it will be maybe the middle of next year by the time they've dealt even with the requests that we have so far submitted. Those amount to, as we've said, 16,270 documents, and we anticipate at a minimum requesting a further 25,000. So we do submit that some deadline will have to be imposed on the prosecution in terms of responding to our requests if the exercise is to be at all meaningful. Finally, with respect to translations, as we have put in our written submissions, we note that many of the documents that we have so far received from the prosecution are not in English, which is the working language of this case. We recall in your framework decision issued on the 23rd of November last year that it was written that the disclosing party must ensure that the evidence, including witness statements, is disclosed in English, the working language of the proceedings. We are therefore requesting that the SBO be ordered to disclose the non-English material pursuant to Rule 1023 that we have been receiving, along with an English translation of that material, whether it is in draft or final format, indicating whichever it is, which we assume was used to evaluate the evidence to determine that it was relevant to our case. Those are my submissions.
Thank you, Mr. Reilly. Mr. Young, please.
Thank you. Just very briefly, 2 points, if I may, on 1023, and then if I may, we're going to ask Mr. Roberts to address you on the issue of suspension and deadlines. So firstly, in relation to an update in relation to the Salimi 1023 disclosure, it's right to say we've received 3 lots of 1023 disclosure in October, 107 items. On the 10th of December, so last week, 4,052 items. And then yesterday we received 1,796 items. So, Your Honour, we've received some 5,000.
Mr. Young, Mr. Young, you were frozen for. Sorry, Mr. Young, you were frozen for the past 15 seconds. If you can just repeat what you just said. Thank you very much. I'm sorry for this.
Well, it is rather freezing here in London. Yes, so I was just indicating that we've received 3 different packages of 102 material, one in October, and one on the 10th of December, another one on the 14th of December. And in total, Your Honour, we've received some 5,900 items of 1023 material, which is some 10% of the items we requested, which goes to some 39,839 items. I can indicate to Your Honour that we have engaged with the prosecution to identify, and we have identified 3,179 priority items to ensure and assist the prosecution focusing on that very important material. Just one other point. In relation to 102.3, Your Honour will be aware that in our filing, we raised the issue of the size and scale of the Rule 1023 items. And I think that at the time of Your Honour's framework decision back in November 2020, the prosecution indicated there would be some 100,000 items on the 1023 list. And presumably, to come up with that figure, the prosecution must have assessed, presumably, these 100,000 items as being potentially material to defence preparation. That's what it's all about. Now, of course, it's right to say the prosecution should always review the figures and their materials, and so the figures can change. I accept that, and they can go upwards and they can go downwards as they realise from the evidentiary holding base there may be more or less than they first anticipated. But what is frankly of concern to the Salimi defence team is that in this case, the figure of 100,000 on the 1023 list was reduced by such a substantial amount. Because as Your Honour knows, the figure that we were provided on the notice, I think, came down to 68,753, some 1/3 reduction in items. Given that these are items which are deemed to be potentially material to the defence preparation, we're pursuing how it can come around and how it can come about that at one moment in time, some 30,000 extra items were deemed potentially relevant to the defence, and then some months later, that's been revised to a much reduced figure. So in order to satisfy ourselves about the methodology that the SPO have deployed in their reassessment or their process of disclosure, Your Honour may have seen at paragraph 13 of our filing, we asked the prosecution to indicate to us what criteria and methodology were applied to identify the 68,000 items identified by the SPO. And we're very sensitive about this because, as Your Honour made clear, I think, in the framework decision, whereas the defence may know the case best, and we can only work with what we're told about. And the reality is, prosecution are making a very important assessment, professional assessment on relevance and materiality. And so we will pursue the prosecution. I just give them notice so that we get an answer to explain how such a massive reduction in the 1023 list is made. And because on the face of it, it cries out for an answer. At the end of the day, as Your Honour knows, and as Your Honour said rightly, I think in the framework decision, it's not for the prosecution to tell the defence what's material to the defence. And identifying what's potentially relevant to the defence may be a much more difficult issue for the prosecution than the defence, because obviously we're in a very different position. I won't repeat what was said last time by my learned friends, Mr. Emerson, Mr. Roberts, about basically, I think, a general request to hand over in toto the entirety of the 68,000. But it may well be we'll need to revisit that if there is no cooperation with the defence in terms of providing us the ones that we at least are able to identify, because as Your Honour knows, we can only identify what's put on the Excel spreadsheet. If I could just now ask Mr. Roberts just to address you on suspension and deadlines, please.
Thank you, Mr. Young. Mr. Roberts, please.
Thank you, Your Honour. I'll be very brief. Obviously, similar to my colleagues, we don't perceive that it would be fair or appropriate to apply any deadline to defence requests for Rule 1023 disclosure. There's no justification for doing so. Obviously, as the case changes and expands and evolves, we need to be able to make requests. We don't need to, or we should not be required to seek leave to do so after the expiration of a certain deadline. So no deadline for us. However, for any requests that we have made, there does need to be, if I can suggest, a carrot and a stick to the prosecution to actually ensure they're complied with. I think an ultimate deadline may be difficult, but certainly a requirement for them to respond expeditiously and a concrete requirement does tend to focus the mind a little bit. How exactly that operates, I think, may well be something that we need to work with the prosecution to do, and as I've repeatedly said, I'm more than happy to do so. I would suggest, though, a little bit of constructive response or a constructive attitude back from the prosecution in this regard. And when we ask for methodology on how they come up with this document, they don't give us a banal and irrelevant response saying we looked at what documents were relevant and we gave those. We're trying to work out how they came up with the list so we can avoid litigation. If they've covered everything, great. I'd be more than happy not to have to litigate issues. But if they don't, then that does actually assist us to knowing that in advance of bringing it before Your Honour. So I would request that they be politely encouraged, if not ordered, to actually respond properly to that request, to provide us in detail information as to how they came up with their list so we can work out what's not on it, what they've removed. Without that,
then we'll just file before Your Honours. But then they complain that we haven't brought it to them first. So in relation to the list itself and the deadlines, I think that's all I would suggest. The one other issue in relation to this, which crosses over to a later question, is Rule 107. We did, subsequent to the status conference, the last status conference, raise the issue with the prosecution in relation to 107 clearance. There was an exchange of emails. They have suggested that they will be preparing a filing very soon on this. I think, as we suggested in our submissions, it would assist us to know when that's coming and approximately how many documents that's relating to. Obviously, the more information we have, the more we can be prepared and therefore plan ahead. So that's my submissions. Thank you, Your Honour.
Thank you, Mr. Roberts. Mr. Beyezu, please.
Thank you, Your Honour. I defer to Mr. Ellis to deal with these issues. Thank you.
Sorry, Mr. Ellis, I forgot. You mentioned to me that you were in charge of this item in the agenda. I apologize. Mr. Ellis, please.
Not at all. Thank you, Your Honour. Our position is essentially the same as that advanced by the Salimi defence, in that we agree with all previous teams that it's not appropriate to set a final deadline for the defence to make requests at this stage. We would, however, encourage the court to consider setting a deadline for the prosecution to respond to requests when they are made. And the background to that, Your Honour, is that in October we made 2 requests pursuant to Rule 1023, totaling some 14,000 documents in total between the 2 requests. Since the last status conference, some 6 weeks ago now, we have received 2 packages. We've received disclosure batch 126, which comprised 41 documents, and disclosure batch 114, which comprised 2 documents. I was surprised to hear the prosecutor say that we'd therefore received 75% of our second request. Our second request was some 5,900 documents. On my maths, which is never something that anyone should rely on, but on my maths that'd be less than 1%. But perhaps there's another disclosure batch imminent. Be that as it may, Your Honour, recently in December we've made a further request for, again in rough terms, another 14,000 documents. And it would appear to me that the whole created by Rule 1023 requests is getting bigger rather than getting smaller, because the volume of new documents being requested is still far greater than the documents being released to us by the prosecution. And that's why we say some deadlines need to be considered for the prosecution to respond. I note that initially in filing 99, the framework decision, the prosecution were to respond to requests within 3 weeks. When the prosecution sought an extension in filing 527, I think the suggestion was that they should have 6 weeks to respond to these requests. At the moment, we're certainly beyond 3 weeks, and I think we're also well beyond 6 weeks. And all of these delays, of course, matter because Mr. Krasnici's now been in detention for more than a year, and it can't be right that all the accused remain there whilst disclosure continues to be delayed. So we would say some deadline does need to be imposed on the prosecution. We suggested, I think, mid-January in our filing for the requests that have already been made. I was tempted to set a shorter deadline, but of course that rather runs into the Christmas recess. So we set mid-January, trying not to be unreasonable, but these requests do need to be dealt with.
Thank you, Mr. Ellis. Let me turn back to the prosecution. If you can answer the questions from the various defense teams, especially if you can give an update on the Rule 107 material and the need to update the list with this material, and also the criteria that you've used to identify all the items on the list, as was mentioned by the Salimi defense in its written submissions. Mr. Prosecutor.
Thank you, Your Honor. Let me start with the criteria. When it comes to the questions by the defense about the way the 1023 list was generated, we have indicated before that the SPO has been mindful of the nature of the Rule 1023 process and interpreted relevance in a broad manner that allows the defense teams to make potential materiality assessments from a wide range of items. The SPO is well aware of the broad standard of relevance previously set out by Your Honour and subsequently endorsed by the Court of Appeals, being evidence in the SPO's possession which has not been disclosed under Rule 1021A or B and Rule 103 and which is relevant to the case. Anyone wishing to ascertain if the 1023 notice conforms to these rules requirements need only to look at it. In fact, there has been substantial discussion about the Rule 1023 notice earlier with the defense teams, and in that discussion it has been suggested that the criteria for generating the list were too broad rather than too narrow. In fact, as recently as August the 4th, after receiving the Rule 1023 notice, the Thaci defense, in inter partes communications with the SPO, insinuated that the notice amounted to, I quote, a repository for the unbridled dumping of all materials apart from a limited set of Rule 1021 and 103 materials. So one can see at first glance that the notice has not been restricted to only that what is directly linked to exonerating or incriminating evidence, and that there is no need for the SPO, or also no basis, to identify the specific basis upon which an item is assessed to be relevant or not relevant. With the Krasniqi defense, we wish to advance this process and see these requests fully processed as soon as possible. I have explained why we have adapted our processing strategy. That was due both to the need to cater to different defense teams in more or less equal measure, and because processing the second Krasniqi request before December the 3rd in its entirety would have meant providing a number of redacted items for which redactions would have to be lifted again a fortnight later in light of the variation of protective measures for a number of witnesses this next Friday. That would have been inefficient for all parties involved, as well as for the panel who would have had to rule on such redactions. Indeed, the difference in our percentage numbers is because I was addressing disclosures before the start of the judicial recess, and it is planned that the Krasniqi defense will receive a voluminous package of 1023 materials this week. More generally, we note that reimposing deadlines for individual requests will likely result in uneven disclosures to defense teams in different periods and a less expeditious output all across the board, as it would hamper concentrating resources on batches of related or like documents across different requests. The SPO has a strong interest in moving this case forward, and where we can, we will. When it comes to the Thaci request for translations of Rule 1023 materials, the SPO has already been adding English translations to Rule...
We'll discuss about that later in the status conference. So.
Thank you. So then I believe there's only the question about Rule 107 left.
Correct.
Indeed, the SPO is continuing to actively work to complete discussions with Rule 107 providers. And decisions are still coming in and are anticipated to be coming in. And given where we are currently in terms of outstanding Rule 103 requests to be processed and the expectation that additional Rule 107 decisions will be coming in the next period, we believe it will be more efficient to all parties to not set a current deadline for an updated relevance list with Rule 107 items, but discuss that at the next status conference.
Thank you, Mr. Prosecutor.
Your Honour, if I may respond to that very briefly.
Mr. Roberts, please.
Without wishing to fall foul of your initial direction, my colleague could have a career in politics because he managed to answer a question without answering it at all. You asked him a very specific question, he neglected to respond to it. You asked him a specific question on my behalf or directed him in relation to Rule 107. He basically shifted it to the next well, next year, next status conference. The point of these status conferences, in my respectful submission, is to move things forward. That will happen when there are clear, straightforward answers to clear, straightforward questions. And I feel if we don't get those, we all come back 6 weeks later and nothing has really moved forward. So I would urge you to direct the prosecution to respond very clearly to those two questions, whether in orally now, or if my colleague would prefer to consult with his team, that's perfectly understandable, in writing before we all go away for the recess. But I really do feel that we need to actually grasp these questions and move them forward. Otherwise, we're just going to push everything down the road a little bit. So I apologize for repeating myself, but I feel that unless actually concrete actions are taken now, we are not going to move this forward. Thank you.
Thank you, Mr. Roberts. Mr. Prosecutor, on the repeated question related to the 107 material, are you able to give us more detailed figures today, or can you commit to inform the defense before the Christmas recess? You have the floor.
Thank you, Your Honor. I believe that we can indeed inform the defense before the Christmas recess, if the defense will address the questions to us with precision and clarity. We will try to get the answers to the defense in the same manner. Thank you.
Thank you, Mr. Prosecutor. I don't see anyone requesting the floor. So in light of the parties' submissions, I will issue a second oral order. I will not reinstate deadlines for Rule 1023 disclosure at this status conference. I expect the parties to continue to work expeditiously towards the disclosure of such material. This includes the defense requesting items from the Rule 1023 notice and the SPO processing of defense requests. I note favorably in this respect that the defense has continued to request items from the Rule 1023 notice, and the SPO is in the final processing stages in relation to 12,500 items requested by the defense and has disclosed several packages of Rule 1023 material. I note further that the SPO has indicated that it will be able to commit more resources to the disclosure of Rule 1023 material in January and February of next year. I accordingly dismiss the Krasniki defense request for a deadline of 14 January 2022 for the disclosure of relevant Rule 1023 material. In addition, and for the above-mentioned reason, I do not see a need to reconsider my prior oral ruling on the procedure for the disclosure of the Rule 1023 material, and accordingly dismiss the Vasilis defense request in this regard. We will revisit the topic of deadlines for the disclosure of Rule 1023 material during the next status conference. This concludes my second oral order. And before we move to the next item in the agenda, I want to insist that I expect that before the next status conference, robust discussion be organized between the SPO and the defense team on this matter, and all the points that have been raised, especially the points raised by the Selimi defense. This includes details on how the notice has been established, and especially the discrepancy between the 100,000 that was announced in the first place and the number that figured in the list. And this also includes the all the matters that have been raised by Mr. Young and Mr. Roberts in their previous submissions orally today. Let us now move to Rule 103 material. Since the last status conference, the SPO disclosed 3 further packages of potentially exculpatory items. The SPO has also indicated that a protective measures request in respect of a small number of items will be forthcoming. The Vasily defense requests that a deadline be set for completion of Rule 103 disclosure. I would like to know whether there remain exculpatory evidence in the SPO's custody, control, or actual knowledge that must be disclosed to the defense pursuant to Rule 103. Mr. Prosecutor.
Thank you, Your Honor. Indeed, we are continuing to conduct exculpatory reviews and run relevant searches for potentially exculpatory material as the witness and exhibit lists are being finalized. And we are, of course, also aware that exculpatory disclosure will remain an ongoing obligation of the Office throughout the proceedings and after the current review exercises are completed. We are also performing quality control and double checks on previously reviewed materials. So indeed, the work on this work stream will continue in the next period. Thank you.
Thank you, Mr. Prosecutor. Mr. Kihu, please.
Yes, Your Honor, that doesn't tell us anything. Going back to what Your Honor had asked on the 102.1b items, how much is left? We're talking about a case that has been under investigation for years, that was indicted over a year ago with the promise that these gentlemen were going to be tried last spring. And we are still, according to the SPO, reviewing certain further material on an ongoing basis, and that the material will be turned over on a rolling basis. This is exculpatory material, which the rule says shall be immediately disclosed. Not yesterday, not last month, not 2 weeks from now, immediately disclosed. And reminding the SPO of what exculpatory material means under Rule 103, it also means evidence that affects the credibility or reliability of the SPO's evidence. Are the people at the SPO reviewing this document with that very important clause in mind? At the last hearing before Your Honor on 29 October, I posited the question whether the SPO was fulfilling their Rule 103 responsibilities, because we knew that exculpatory statements had been given to the SPO by individuals that we have talked to. Now, we can get into the witness issues later on. And I searched in vain for the 386 documents that were disclosed pursuant to Rule 103. And that statement, again, was not turned over. And a rhetorical question is, if that statement is not turned over by a very competent witness in the international arena, what else is not being turned over? What else has not been given to the defense? What else falls in the category of Rule 103 material that we wait in vain for? It's very disturbing, Your Honor. It's very disturbing. And it makes me question, frankly, it has to make one question, how this 103 material is being examined and how it is being determined that it is in fact 103 material. Because I know, as I stand before Your Honor as an officer of the court, they have not turned over 103 material, and we wait for this information that we should have had a long period of time. My client, with the rest of these gentlemen, have been here in custody for over a year, and the prosecution is still reviewing matters on a rolling basis? Question, Judge, if there was Rule 103 material, would Your Honor not want to have seen that material when assessing the pretrial release issues? Of course you would, Judge. Of course you would. As a learned jurist, you would take that and everything else into consideration. But it's not coming. And that is problematic. Now, we will see how quickly this other material comes across the transom and how much is involved. And in the very near future, we're going to have to address this lack of disclosure. The lack of disclosure certainly on a timely manner, and the lack of disclosure when it comes to the content that your honors would have want to have seen in making an array of decisions that you've made. I end this, Judge, with one comment. The disclosure under Rule 103 has been very disturbing. Thank you.
Thank you, Mr. Kihu. Mr. Strong, please.
Yes, just to add to that, from our perspective, this information is so important because we're trying to organize our defense case and our timeline. And to date, I don't think that I've heard any timeline at all throughout these proceedings as to when we can expect, when we can anticipate to see this 103 material. Obviously, the deadline will be rolling as new material arises. The prosecution has an obligation to give it to us. But in terms of what's in their possession at the moment and what they control now, we need to get some clarity on the amount and when we can expect it so we can start to make our preparations. Thank you.
Thank you, Mr. Strong. Mr. Young, please.
Nothing to add. We completely support the submissions of Mr. Kehoe. And also, I would also support, having reread the transcript of the last status conference, the concerns of Mr. Emerson expressed then about his concerns over a lack of disclosure of exculpatory material. Thank you.
Thank you, Mr. Young. Mr. Ellis, please.
Your Honour, we support the submissions that have been previously made by the other defence teams. On this issue, we have had essentially the same submission from the prosecution at each of the previous status conferences. It can't be the case that this just keeps being reviewed on an ongoing basis with no actual deadlines set. Of course, as new material comes in, it needs to be assessed pursuant to the prosecution's obligations. But for the material that they have already, why can't a deadline be set now? They've had a year already. Our clients are in detention. They must be able to review what they have already and tell us what is exculpatory in it.
Thank you, Mr. Ellis. Mr. Prosecutor, what would you like to reply?
Thank you, Your Honour. We have indeed indicated that the review of the materials is ongoing. If defense teams, for whatever reason, wish to identify items that they are apparently wishing to be reviewed with priority, they are welcome to inform us of those, and we will expedite their review accordingly. And we would believe that would be more effective than a repeatedly abstract discussion about such items on these status conferences. We are well aware of our obligations for the exculpatory review and disclosure, and we are working hard on those as well as we are working on the other disclosure obligations. Thank you.
Thank you, Mr. Prosecutor. Mr. Q,
very briefly, Judge, if they're well aware of their obligations, we respectfully ask that they meet them. It is not the point of, it's not the role of the defense at every turn to attempt to squirrel through the files of the SPO to try to find out what they have. We know they have exculpatory information, and we also know that it came from very competent sources. And we also know, most importantly, that it hasn't been turned over. When, Your Honor, will they make an end? When will they complete the disclosure of Rule 103 material? That's essential as this case moves forward. That's essential, Your Honor, for information that we would present to Your Honor for pretrial release come January, which I suspect we probably will be, where we probably will be. But as time goes on, it just doesn't happen. And there will come a time when we will present it all to Your Honor. But in the interim, we simply ask for the prosecutor to fulfill their obligations without giving this. We're constantly reviewing this, and we're going to do this on a rolling basis, and the rolling basis can roll well into 2022. That will not suffice. Thank you.
Thank you, Mr. Kihu. So I regard the defense request for a deadline for disclosure. I mean, I can recall that in my framework decision on disclosure, the famous F99, I noted that the requirement is that the SPO immediately disclose all exculpatory material in its custody, control, or actual knowledge. And this obligation is a continuous one. This is why I ordered the SPO to disclose the material as soon as practicable on a rolling basis, particularly when the material did not require redaction. Setting an outer deadline for disclosure of this material could potentially undermine this continuing obligation. This is why I refrain from reconsidering my framework decision on disclosure and setting such a deadline at this point in time. But, nevertheless, I remind the SPO of its obligation to disclose exculpatory evidence immediately as soon as it is in its custody, control, or actual knowledge. And I also remind the SPO that only justifiable reasons, such as the need for reductions, may prevent immediate disclosure. So if there is still a need to double or triple check the database of the SPO, it is definitely the time to do it. This cannot wait. It has to be done as a matter of priority. So we are supposed to go on a break very soon, but if the interpreter allow me, I will take just a couple of minutes to finish the last item on disclosure that should be very brief. And I turn to the interpreter. Can I have just a couple of minutes? I promise it's not going to...
Yes, Your Honor.
Very much. So I promise the interpreters to be very brief, so I expect the same from the party. We will now move to the Rule 107 material. I would like to know whether the parties are facing or foresee any difficulties related to disclosure process with respect to Rule 107 material, and whether any application pursuant to this rule are imminent. I note the SPO submission that is continuing to actively work to complete discussion with Rule 107 providers. Mr. Prosecutor, do you want to add anything on this category of material?
No, thank you, Your Honor. I have nothing to add to our written submissions and the discussions we have had. Thank you.
Thank you, Mr. Prosecutor. Does any of the defense team want the floor? Mr. Kihu, please.
Yes, Your Honor, nothing from my client.
Mr. Emerson?
Nothing, thank you.
Mr. Young, please.
Nothing, thank you. Our submissions are in writing.
Thank you, Mr. Young. Mr. Ellis, please.
Nothing to add. Thank you, Your Honor.
Thank you very much. Then I think I respected my promise to the interpreter, probably even more than faster than I thought. It is now 4:33. We will break for 20 minutes, and we will come back in the courtroom to discuss the next item in the agenda, which is translation, at 4:53. The hearing is adjourned.
All rise. All rise. Please be seated.
Let us move now to the issue of translation of filings and evidentiary material. I would first like to hear from the registry on the progress made in regards to the translation of these items, notably whether the parties have made any further urgent requests for translation, and whether the registry can give an estimate for the translation of the SPO pretrial brief. I would also like to hear the parties on any further difficulties regarding translations and if there are filings that need to be prioritized. I also note the submissions of the Vesely defense regarding the translation of Rule 1023 material. The Vesely defense requests that I order the SPO to disclose the English translation of the Rule 1023 material. I will first give the floor to the registry. Mr. Roche, please.
Thank you, Your Honour. The first item is previous request for prioritisation. The SPO preliminary witness list had been prioritised. That was filing F542 Annex 02. That was distributed in unrevised form on the 2nd of December ahead of the previously indicated timescale. As regards the pretrial brief, we currently are not able to give any indication of when it would be translated. This is because it has not yet been filed, and it will need to be the subject of a review by Language Services Unit to assess the complexity, whether some of the contents are already available in the other official languages of the chambers, etc. So currently we're not able to give a firm indication. It is going to be a matter of the utmost priority for translation in case 6, and we will of course provide a firmer indication of when it will be ready as soon as that is available. So we will immediately assess it once it has been filed and then provide that timescale as quickly as possible. More generally concerning translations in general, obviously all of the documents that are filed and required to be translated into Albanian have been. And there is a total of 218 filings or documents which have been translated into Albanian. That constitutes 5,713 pages. As regards other requests for priority or urgent translation, we have not received any over and above the preliminary witness list. Thank you, Your Honour.
Thank you, Mr. Roche. Let me turn to the defense. Mr. Kihu, please.
I have nothing, Your Honour.
Thank you, Mr. Kihu. Mr. Emerson, please, or Ms. O'Reilly?
We have nothing further than the submissions we made earlier on Rule 1037.
Thank you, Ms. O'Reilly. Mr. Young, please.
Your Honour, really we have little to say, save that obviously the most important document for translation will be the pretrial brief, which is, as Your Honour knows, due to be filed in 2 days' time. My submissions would really depend upon Your Honour's response to paragraph 26 in our written submissions, because Your Honour may recall in paragraph 26 of our written submissions, I asked Your Honour to reconsider Your Honour's decision to grant the prosecution a triple extension only a matter of a few days ago, just before the date of the service of the pretrial brief. And we've set out our submissions in writing. I don't really feel they be improved orally, but obviously whether you reconsider that or not is obviously going to be a very significant matter, because Your Honour may recall with the other document that was a significant one to be translated, namely the prosecution outline, I think it took some 6 months to translate it into Albanian. The pretrial brief is going to be one of the most important documents that the accused must be able to read carefully in their own language. And so Your Honour might want to consider that when reflecting on whether you should allow them to triple the standard size of the pre-trial brief. As Your Honour knows, the prosecution filed the extension request on Thursday last week. Within 3 hours, Your Honour granted the decision. We filed 1 minute after Your Honour's decision. So it's a matter for Your Honour. There's nothing more I can say.
Thank you, Mr. Young. Mr. Bayezou, please.
Thank you, Your Honour. As regards the item 2B, the defense did not make any urgent requests for the translations. But there is an important point to be made in respect of translations, which to some extent overlaps with the other agenda items regarding the pretrial brief and the related material. Now that the pretrial brief tripled in length since last week, the resources available for translation in our submission should be prioritized, focused not only on the remaining Rule 102B material, but mostly to translate as expeditiously as possible the pretrial brief and the supporting material. What we don't want is what occurred with the translation with the SPO's outline and the prosecution provisional list of witnesses, where it took about 6 weeks to produce the Albanian translation of this list. It's clear that Mr. Krasniqi needs to see this document, the pretrial brief and the supporting material sooner rather than later, just as the defense requires these documents to advance with these investigations. We also support and adopt the written submissions of the Vizelli defense, that is filing 613, with respect to the need to prioritize the translation into English of the disclosure of 1023 material, which is in multiple languages other than English. Thank you.
Thank you, Mr. Bayezou. Mr. Prosecutor, can I have your submissions on the request by the Vizelli defense on having all the 1023 material translated in English? This was in their written submissions.
Yes, Your Honour. The SPO has already been adding English translations to Rule 1023 requests where available for some time now. Such translations are not available for items that have been reviewed by SPO staff speaking the relevant language or through site translations. There is no obligation for the SPO to generate translations of 1023 materials. Such materials cannot be equated to evidence being relied upon by the SPO. And granting a request to order such translations would take away substantial language resources from review and redaction of foreign language materials for different disclosure workstreams. Therefore, the SPO requests Your Honour to deny the request.
Thank you, Mr. Prosecutor. I have a follow-up question on this. Can you give me a very broad estimate of the number of evidentiary material it concerns, if you can, and you can take a minute if needed, because I'd like to know if we are talking about 10 items, 100 items, or 1,000 items. And if I may add, I think the Vizelli defense indicated that this applies to multiple languages, I think 33 languages, as you mentioned in your submissions, if my memory is correct.
Well, no, apologies, we were saying that 33 are in a language other than English. Our point was that it's not just that they're in Albanian or Serbian, but in all the languages that were spoken by the various parties were in Kosovo during that period, such as the various K4 contingencies.
Thank you. This is noted. So also, if you have an idea of how many languages this material refers to.
Yes, Your Honor. I say this with some caution, but I believe it will be thousands of items. Surely, if the defense team who is making this request will be able to indicate with more precision which items they feel are lacking a translation at the same time. It is very difficult for me now to generate reliable figures because we have multi-language items. As I said, the SPO is disclosing all translations that we already have to the defense teams, regardless of whether they have been specifically requested or not. So we would have to have different subset of documents to see how many translations there are. But it would be a very substantial number. And as I said, it would take away translation resources from other disclosure work streams, whereas we believe the materials covered by the 1023 process are fundamentally different than the materials covered in 1021B and 103. Thank you.
May I suggest that between now and the next status conference, the parties have discussions on finding, I wouldn't say an alternative way, but a pragmatic solution in order for the parties to understand with more detail what each item is about so that the defense can really assess if they will request it. Because I understand from the defense that they can really not assess if the document is material for the defense if they cannot understand it. On the other hand, I also understand that if we're talking about thousands and thousands of documents, and if in the end these documents are not material for the defense, it would be a waste of resources for everybody. So is there a possibility that there is inter partes discussion so as to give probably more detailed about certain documents without translating the totality of the documents? Would this be a practical solution? Ms. O'Reilly.
Well, Your Honour, one assumes that that information already exists, because even if they were having Albanian or Serbian or other speakers reviewing this information, they would have had to record their observations in English so that the team in general could understand. So I would assume that information is already available to be disclosed to us. Should there be any work product in the mix there that isn't subject to disclosure, that could of course be redacted. But we would assume it's a relatively straightforward exercise for you to simply order them to do that already today. We are, of course, happy to engage with them further on the materiality relevance issue, and perhaps this, if you're not minded, to make an order today. Thank you.
Mr. Prosecutor.
Your Honor, the SPO is always open to constructive inter partes discussion on any issue that is between us. I do note, though, that we have had discussions before about the nature of the Rule 1023 process and about the information that we have been providing in with more detailed descriptions, geographic criteria, names, dates, places, that would allow the defense to make first estimates of what would be potentially material and what would be not. We have had discussions before when it was suggested that the SPO should disclose all Rule 102.3 materials, that it is not for, and in fact we have had them today, that it is not for the SPO to do the defense, to make the judgment about what is potentially material to the defense case and what is not. And I have a hard time, and therefore to equate the review that the SPO has conducted of such items with the review that the defense will then conduct of such items, I think will be very difficult because they regard to a very different level of information, and they also regard to a judgment call by the defense that we cannot make. And certainly we don't have all the information that the defense needs. What needs to be done, we believe, is that the defense selects documents that are on their face potentially relevant material to their case and will then have to process them in the way they see fit. So yes, we are open to inter partes discussions, but I am giving a word of caution that we believe the information available and the role each party plays in the Rule 1023 process is very different, and we can probably only assist in a limited manner. However, we are always open to discuss in what manner that may be.
Mr. Emerson.
Your Honour, I would just point out, as I have been doing periodically during the course of the agenda, that to the extent that the SPO in this instance casts the burden of translation on the defence, then it necessarily follows that the process is going to be that much longer, because of course the defence resources are not inexhaustible either. So if we don't know what the document, I don't know to what extent the volume of material in a language we don't have resources for it is going to impact on the timeline. But as I've been pointing out as we've gone through, the timeline for trial is looking very pessimistic. And of course, to the extent that the SPO takes the view that the appropriate distribution of responsibility must devolve to the defence on this material rather than the prosecution in serving it, then of course that will prolong matters even further.
Thank you, Mr. Emerson. I will not rule on this matter today, but I invite the parties to have discussions on this issue. I also invite the parties to find constructive solutions. I think it's in the interest of all the parties. And I invite the parties to indicate in their submissions before the next status conference the result of these discussions. And I also invite specifically the prosecution after this discussion to indicate with more precision how many documents, how many items we're talking about, and also in which language. So I invite the parties to brief me before the next status conference. I now turn back to the SPO to ask about the status of its ongoing investigations. At the last status conference, I ordered the SPO to file its pretrial brief and related material pursuant to Rule 95 by 17 December 2021. I further ordered the SPO to file its Rule 109C chart by 28 January 2022. I would like the SPO to confirm that it will respect these deadlines. Furthermore, I would like the SPO to indicate whether it can provide a further update on the estimated date of completion for outstanding investigative steps, if any. I also invite the SPO to make any submissions on the procedural calendar in this case. I also note that on 9 December 2021, I granted the SPO an extension of the word limit to 150,000 words for its pretrial brief. And I further note that the Krasniki defense and the Selimi defense requested reconsideration of this decision. I would like the parties to give their views on this request for reconsideration. Mr. Prosecutor.
Thank you, Your Honour. With respect to ongoing investigative steps, the SPO's position is the same as at previous status conferences. It remains the case that it is the responsibility of the Office to continue to investigate within its mandate. We are aware of the applicable framework and that should such further investigations result in material which we seek to rely upon, judicial authorization may be required. Any such application would be considered at the relevant time with regard to the nature of the material in question, the timing and other considerations going to relevance and potential prejudice. The SPO does not currently anticipate difficulties regarding the 17 December 2021 deadline for Rule 95.4 materials or the deadline of 28 January 2022 for submission of the Rule 109C chart. The extension of the word limit for the pretrial brief was granted for good reasons, taking into account the nature, geographical area and period of the charges, the number of victims, and the number of evidentiary items. The word limit as amended is eminently reasonable, and the request for reconsideration should be denied. Thank you.
Thank you, Mr. Prosecutor. Mr. Kihu, please.
Yes, Your Honour. I would like to address first their ongoing investigations, and if I can turn the issue concerning the 150,000 words to Mr. Misicic, with Your Honor's permission. What the SBO seems to not have grasped is that the ability to continue to investigate is not given as a matter of right. We have seen a series of comments by the SBO concerning conducting investigations. And their investigations encompass other cases and other investigations being conducted by the office. And I refer to the hearing before Your Honor on 21 July 2021 at page 508. That was reemphasized again in September the 14th of 2021 when counsel said the same thing. The last time we were here, Judge, I raised Rule 47 concerning the completion of an investigation. And there are certain requirements under Kosovo law that don't appear to be being followed by the SPO. Now, under Article 2221 of the prior law prior to 2012, that the investigation had to be initiated by the public prosecutor. The ruling shall specify the person against whom the investigation will be conducted, the timing of the initiation and investigation, a description of the act which specifies the element of the criminal offense, and all the other measures concerning that defense. That statute was amended in 2012, which incorporated not only what was going on with the Special Investigation Task Force, but also thereafter in 2012, which said that the investigation has to be triggered by a decision made by the prosecutor. And the decision has to, and this is Article 104 of the amended statute. Decision shall specify the person or persons against whom an investigation will be conducted, the date and time and the initiation of the investigation, a description of the act which specifies the elements, etc. And those details have to be given in writing to a pretrial judge. Now, why is this significant? Because the law in Kosovo, Article 224, and thereafter the amended statute 159, Article 159, puts limits on what the prosecutor can do. Article 224 noted that the prosecutor shall terminate the investigation if at any time it is evident from the evidence collected that the period of the statute of limitations for criminal prosecution has expired. The amended statute that came in 2012 in Kosovo restricted this yet further and put a 2-year time frame on this. Article 159, if an investigation is initiated, in other words, the prosecutor gives a written order to the pretrial judge initiating an investigation, the investigation shall be completed in 2 years. With permission of the pretrial court, it can go to another potential 6 months. What are we investigating here, Judge? What document has been given to any pretrial judge to justify this additional investigation? If, in fact, my client continues to be investigated in an open-ended fashion on some thin argument that they're fulfilling their mandate, when in fact they're investigating other things, we ask that this investigation be terminated. Again, as with the 102 material and the 103 material, this investigation has to come to an end. And we request, Your Honor, again, we asked the last time, and I believe Your Honor deferred, that this investigation be terminated. I mean, is the filing of this pretrial brief the end of this investigation? I'm sure Your Honor would want to know. I mean, this is right around the corner. It's next Friday. Or are we talking about another investigation that's going to continue on in heaven knows how long? Because they don't, SPO, once again, as with the exculpatory evidence, don't put any time parameters on what is going on with this investigation, when it will be completed. And I will say, Judge, Your Honor asked a specific question about that, when it's going to be completed, and Your Honor didn't get an answer. So we have an open-ended investigation. We don't know when this started. We don't know what the parameters of that are. We don't know what documents have been given to anybody to justify this investigation by Mr. Williamson or anyone else, or Mr. Smith or anyone else. But the rule clearly provides that after a given period of time, that the investigation be terminated. So we ask once again, Your Honor, to terminate this investigation and let us deal with the indictment that's before us and put an end to all the other ancillary investigations that counsel for the prosecution has been referring to over the past 6 months. This cannot go on forever. There has to be an end. There has to come a point, Your Honor, where you as the pretrial judge have the information that you're going to transfer over to the trial panel. According to what they just said, we're nowhere near that. So we ask once again for Your Honor to shut any further investigation down as we move forward and let us deal with what we have before us. Now, on the issue of the 150,000 words, if Mr. Misicic can address that issue for Your Honor, with Your Honor's permission.
Mr. Misicic.
Thank you, Your Honor. First, we note for the record that we didn't have an opportunity to be heard on this question, and so we do that now. We do object to the extension of the word limit, in addition to the argument that the Salimi defense put forward in terms of how much this is going to delay things due to the need to translate a document, which we estimate will now move from about 100 pages to about 300 pages. There is another concern, which is, and we say this not having seen what's going to be filed on Friday, but putting this on the record now in case we have to raise an issue after it's filed. We understand the purpose of the pretrial brief to, among other things, streamline the case so that the defense has notice of what not only the allegations are, but what the evidence is that is going to be used to support that particular allegation. If the extension of the word limit is really now being designed so that we can get footnotes that are pages long so that we're citing every conceivable document that might be related to a particular allegation, it defeats, in our view, the purpose of the pretrial brief because it just basically continues to make the water muddy and not clear, and therefore will make the defense investigation much longer and will keep us more in the dark about what is actually the evidence that the prosecution intends to rely on. For that very purpose, we were hoping that the pretrial brief would actually force the prosecution to be very focused on what are the actual allegations in the case, what is the evidence that they really rely on, and then we could have hopefully streamlined both the defense investigation and the trial in this case. And for that reason, we would have asked that the word limit not be extended. Thank you very much, Your Honor.
Thank you, Mr. Misicic. Mr. Emerson, please.
On behalf of Mr. Vasili, we take a slightly different approach. So far as we're concerned, the paramount consideration is that there should be no delay on the 17th of December deadline. And if the consequence of a reconsideration would be to put that deadline back, then we regard that as the worst of two possible scenarios. So that's the first thing. Of course, I join the other teams in registering our concern that the decision to extend by this extent was taken without reference or without the observance of the audi alteram partem rule, that both sides to an issue should be heard, and we are slightly surprised that that would have happened on an issue of that kind. But I, for my part, am willing to take at face value the prosecution's assertion that it considers it necessary to reflect the full scope of the case it wants to reproduce at trial, to apply for an extension to 3 times the length permitted by the rules. And I take it at face value that since Your Honour didn't think it necessary to consult the defence, you must have been convinced that nothing the defence said could have deflected that. Therefore, we proceed on the basis, as it was put to you just a moment ago by the prosecution, that 3 times the length permitted by the rules is, quote, eminently reasonable given the sheer size and scope of the case that they're setting out to prove. I just want to put that in a little bit of context. That is twice as long as the pre-trial brief in the case against Slobodan Milosevic at the ICTY, which concerned the conflicts in Bosnia, Croatia and Kosovo, spanning a 10-year period. It is 3 times as long as the pre-trial brief in the genocide case against Radovan Karadzic concerning the massacre at Srebrenica and a whole slew of other crimes against humanity perpetrated against the Muslim population of Bosnia. So clearly, in the prosecution's view, the scope of this case, evidentially, is much, much greater by several factors than the scope of either of those 2 cases. So we take that at face value, and we take Your Honour's decision summarily to permit it without argument at face value, and therefore, when we look again at the scope of the undertaking that the prosecution is forcing onto this tribunal and onto the defence, we ask ourselves, what is the length of time that is going to be necessary before this trial starts, and what is the length of time that can conceivably be necessary before it finishes? Bearing in mind, as I said, I think to Your Honour on an earlier occasion, that to send this case for trial to a trial chamber with the prosecution asserting the necessity to call more than 300 witnesses presages a 3-year plus trial based on the evidence experience of other comparable tribunals. So there it is. We take it at face value that this case is deemed to be disproportionately huger than the Milosevic trial. But let us see then what the prosecution has to say about the implications of that for the management of the case.
Thank you, Mr. Emerson. Mr. Young, please.
Thank you very much. Well, let me start by saying, of course, we completely understand the points made by Mr. Emerson, but we also make it clear that we do object to this triple extension, and we ask for reconsideration. The two main points are, of course, that Your Honour did not seek, as Mr. Emerson said, Your Honour did not seek any consultation with the defence, or not seek to give the defence an opportunity to be heard, and nor did the prosecution give any indication at all that only a few days before the pre-trial brief, which presumably has been written many, many months ago, that they would be asking, just before it's due to be served, for a tripling of the word extension. And the 3 points I make are these. Firstly, just to remind Your Honour that, if I recall correctly, on a number of occasions, I understand that Your Honour has asked for written filings from the parties in relation to quite modest word extensions on quite modest filings of the order of 1,000 to 3,000 or 4,000, for example. Here, in contradistinction, we have not 1 or 2 or 3,000. We have an extension from 50,000 to 150,000, and yet the defence isn't even asked to be heard. And so, with respect, the logic is beyond me, that if it's important for even the minor word extensions, why is it that on possibly the most important word extension application, we weren't even notified by the prosecution, let alone with respect to your good self? So the second point I make is in relation to the standard practice direction, because we rely upon the practice direction. I'm relying upon Article 44 of the Registry Practice Direction on Filings, which Your Honour knows. And so that's the practice direction. It's there for good reason. And obviously those that drafted the practice direction in relation to these cases considered it carefully and came up with a formula: 10,000 words for contextual background, 10,000 per accused. And yet Your Honour has now added 100,000 to that practice direction of the registry. The third and final point I make is one of clarity. And succinctness, because, and I'm referring now to paragraph 30 of our filing, I do rely upon what the appeals panel said in a recent request for an extension of words, where they reiterated that the quality and effectiveness of submissions do not depend on their length, but rather on the clarity and cogency of the presented arguments. So we do submit that that rationale should apply to the prosecution's pretrial brief. And with respect, I do respectfully remind Your Honour that Your Honour on almost every status conference, and I understand the reason why Your Honour does it, you remind counsel to be succinct and clear and short in their presentations. Yet in this breathtaking example, Your Honour allows 100,000 word extension without even giving us an opportunity. It's a clear and obvious breach of natural justice, and it won't advance the case. It will only cause prejudice to the defence, and we do submit that it will simply cause greater confusion, obfuscation in relation to an already wholly vague case. Thank you very much.
Thank you, Mr. Young. Mr. Bayezu, please.
Mr. Ellis is going to address this issue with your permission.
Thank you, Mr. Bayezu. Mr. Ellis, please.
Your Honour, thank you. In relation to the ongoing prosecution investigation, we've heard exactly the same submission from the prosecution again at, I think, all 9 of the status conferences to date, namely that without giving any really specific information to Your Honour at all, it said that the investigation is ongoing. There has to come a point where it stops, where this case can move forwards. And the difference between this status conference and previous status conferences is that we have the pretrial brief due in 2 days. In our submission, the time's come for this ongoing investigation to be brought to a close, and I invite Your Honour to order that today. As to the extension of the word limit, Your Honour, we have put our views in writing in our request for reconsideration. It was not a request that we made lightly, Your Honour. It is a real source of concern to the defence that an extension of this size was granted so quickly and before we had the opportunity to put our submissions in response. We, of course, appreciate the complexity of this case, having been involved in it for more than a year now. But at the same time, it must have been apparent to the prosecution before the 9th of December that they were going to exceed the 50,000 word limit. There's no reason why the defence couldn't have been put on notice of that at an earlier point in time, and why it couldn't have been raised before Your Honour at an earlier point in time. And for the reasons given in our written submission, nothing in the prosecution's reasoning in seeking an extension justifies the size of extension that was sought. A tripling of the word limit is a dramatic increase. And I don't want to repeat everything that's in the written submission, Your Honour, but we maintain those submissions. We would not have opposed a more modest extension.
Thank you, Mr. Ellis. Mr. Prosecutor, do you want to add anything?
Your Honour, just before
Emerson,
the
briefly.
prosecution replies, may I make it absolutely clear that not only am I not applying on behalf of Mr. Vasili for a reconsideration of the order, but I'm actively opposing such an application.
Thank you, Mr. Emerson. Mr. Prosecutor.
Thank you, Your Honour. I will be very brief, and I will note only that the provisions cited by the Thaci defence were not incorporated into the rules and do not apply before this court, except for Rule 47 of the rules, but that only addresses investigations when there is no indictment. It does not apply to this case. The relevant provision for late disclosure in this case is Rule 102, and as said before, the SPO is well aware of it. Thank you.
Your Honour, may
you,
we
Mr.
briefly respond to that
Mr.
last legal
Kehoe,
point, and I'm going to turn
you-
to Mr. Dosted Palaska for
Can you wait for me to give you the floor, please?
my apologies.
You have the floor. Thank you.
My apologies, Judge, and I just will hand this to Mr. Palaska.
Mr. Palaska, please.
Thank you, Judge. We realize that the prosecution acts and behaves as if this court does not belong to Kosovo, and which would render the court extraordinary under the Constitution and therefore prohibited. But the test under Rule 47 is the test under the Rule 47 is very clear. It requires, it gives the right to the suspect to make a motion for termination of the investigation in case indictment is not issued within a reasonable time. To what Mr. Kehoe referred in his earlier submission was that one of the key preconditions for making this determination is to determine the time when the investigation started. And we respectfully submit to you that the investigation started actually before this law, before the law was enacted, before this court was created. It started with the investigation of Mr. Clint Williamson, and the law in effect at that time was the Criminal Procedure Code of Kosovo, either the provisional one or the one that was adopted later. That is why the provisions that were cited by Mr. Kehoe are relevant for this exercise. We still don't have the decision for the initiation of the investigation, which is the procedural act that marked the beginning of the investigation. We need to know whether our client was named in that decision as a suspect, as that would serve as the basis for determining whether the indictment for these ongoing investigation has not been issued within a reasonable time. That's why we oppose the explanation that was given by the SPO. Thank you.
Thank you very much, Mr. Palascal. I will issue an oral order on the matter we just discussed at the end of the status conference. Let us now move to the next point in the agenda, which is the defense investigation. I would be interested to hear the defense regarding the status of their investigations. Mr. Kehoe.
Yes, Your Honor. Yes, we have been investigating. Yes, we are out talking to witnesses. We have been contacting witnesses. We have been contacting witnesses that are on the prosecution's list of witnesses, and we will continue to do so, putting aside these draconian measures advanced by the prosecution to invade the defense camp. I will tell you, Your Honor, that nobody has objected to being interviewed during the course of our investigation, and notwithstanding the fact that the prosecution improperly has told all of these witnesses to immediately advise them, the SPO, if in fact that particular witness is contacted by anybody in the defense. With regard to the investigation itself, let me say this at the outset, and this goes back, and I'm not attempting to revisit Your Honor's ruling on pretrial detention, but I must urge on Your Honor how it has become yet more problematic to have our client to assist in his defense for one simple reason, very, very simple reason. The detention unit has limited the amount of people to go into the detention unit at any time to talk to my client or any of these other clients to investigate this matter to 2. We cannot bring any more people into the detention unit because of COVID. This is going to have a dramatic impact as we move forward on our ability to investigate this matter. With the release of these gentlemen on pretrial release, under the conditions set forth by the Kosovo police or third-party countries, we would be able to continue this investigation. We would be able to sit with our client in a forum that would allow for more than 2 people to sit down and talk to him so we can get to the bottom of this investigation. Your Honor, we're about to take on a 300-page brief to be followed by heaven knows how many documents in a chart to come at the end of January. That is an enormous amount of work to expect 2 people for protracted periods of time to go into the detention unit to talk to my client and for other counsel to talk to their respective clients. There are not only is there number limitations, and I'm sure Your Honor is aware of this, there are time limitations. You have till approximately 11:45 in the morning if you get in at 8:30 or 9, depending on how the detention unit works. And then you can only get back in at 1, and then you have to be out by the latest 4:45. Is it possible to meaningfully have our client assist us while he continues to be in the detention unit with these restrictions that come out of as a result of COVID? I submit to you it's not. That being said, we will continue as best we can to investigate these matters, putting aside the draconian measures advanced by the Office of the Prosecutor, where they attempt to invade the defense camp. But I have to bring before Your Honor the point that the restrictions on our ability to consult with our client have been significantly hampered, unnecessarily so, because he is in the detention unit, and much of this could all be alleviated if he was just permitted, with Your Honor's permission and restrictions, as Your Honor has ordered it, to go back to Pristina and allow us to conduct our investigation there. I simply can't give, Your Honor, and I suspect my colleagues can't either, give you an operative time frame when we can potentially conclude this investigation under these very severe restrictions, which takes me back to my point, given the fact that we will probably be back in January with another motion, that Your Honor convene a hearing where we can vet these issues and talk to the people from the Kosovo police or third parties to allow the court to understand what kind of restrictions are going to be on our respective clients, how they're going to abide by Your Honor's ruling, and allow just for once some Albanian Kosovar to go back to Pristina and be released on pretrial detention. Thank you.
Thank you, Mr. Kihu. Mr. Emerson, please.
In answer to the question about the defence investigation, I think I've made it clear all the way through that the defence investigation can begin seriously to be scoped once we receive the prosecution's pre-trial brief. And so in the expectation, or hope and expectation, that that will be this Friday, just before the Christmas vacation, which will therefore take a month in effect out of any effective operation on the ground, we would expect to be able to scope from mid-January. But the scale, and that's why I have been popping up and down periodically throughout this status conference, to just focus on what the scale is of what's being suggested here, it presages a gargantuan and extremely difficult pre-trial investigation period. You'll notice I've worn my mask all the way through this hearing. That's because I come from a part of the world where the latest strain of coronavirus is now out of control. And there's every reason to expect that will continue to be the position, and that it will peak around about January or February. And as we all know, the existing regime of vaccinations is largely ineffective, 20% protection for those who, unless they've been vaccinated either 3 or 4 times. So we're in a situation where we'll have all of those difficulties as well. The submissions that we would wish to make to you in relation to the Gucciati witness protocol, we will put in writing as you have indicated, and indeed we should be in a position to file them within the next day or two. But I can say straight away, there's a protocol that was designed to deal with a case in which there were a total of 3 prosecution witnesses. It will double, or more than double, the length of time it would take to investigate this case. Just to be clear, just to be practical about it for a moment, the way the prosecution suggests it should work is that, let's say we see a witness who was a senior member of the Kosovo Liberation Army, perhaps we worked or fought alongside them, and they're being called as one of the 300 witnesses that the prosecution has sort of slewed into this case, which essentially covers a very large number of the people in Kosovo who fought in the conflict as well. We have to ask the prosecution under this arrangement to ask them if they would mind flying to The Hague at their own expense, it seems, to be interviewed by the defence in the presence of the prosecution and in the presence of the registry. Now just think about it, 300 witnesses. I mean, it's a completely unworkable proposal. So we'll put that in writing as we move forward. As far as the submissions that have been addressed to you in relation to detention is concerned, we agree that there needs to be a final and full bottoming out of the concerns that have been expressed about the reliability and enforceability of the guarantees offered by the Kosovo Police Service. I'm not going to go into what the prosecution said in its confidential filing, although you've asked, I think, for some clarity about whether that should remain confidential. We say it certainly shouldn't. I think it's very important that the Kosovo institutions know what the prosecution think about them and know what they say about them and know what kind of material that they rely upon. That's important in the public interest. It's also important because the public in Kosovo want to see these proceedings being conducted fairly, and they are, I'm sure, no doubt rightly scratching their heads as to, as what Mr. Kehoe put it, what more could the police do other than tell you they would do everything you've asked and they would do it by consent, so there's no need for a legal basis. You will know, and I'm not going to make an issue out of it, but we have appealed your decision on the grounds of both apparent and actual bias, on the basis that the way in which you reasoned it makes it pretty clear that this court had no intention of granting provisional release under any conditions that were offered. And to the extent that you relied upon things you said were not sufficiently explicit in the representations that were made by the police, that's completely inconsistent with the ruling of the Court of Appeal, which directed you to seek further investigations on anything you didn't know about. So we would support Mr. Kehoe's submission, really regardless of the outcome of the appeal. But let it be clear, the Kosovo Police Service was asked by you in great detail what they could do. And they answered in very great detail as to what they could do. And yet, it appears to those outside the courtroom that that exercise was a futile one from the start, because the flaws that were found in the response that was given were all questions that you could have addressed to the Kosovo Police Service at the time before ruling, just as the Court of Appeal said you should have done on the last occasion.
Thank you, Mr. Emerson. Mr. Young, please.
Your Honour, thank you. Just very briefly, to update Your Honour that we have commenced investigations. We are at the very early stages and have secured a professional investigator. But the reality is that embarking on defence investigations will very much depend upon the clarity and the assistance we get from the pre-trial brief of the prosecution. At present, the defence are wholly unclear about the case against Mr. Salimi. And we're also suffering massively from a lack of information, redactions, delayed disclosure and all sorts. So at present, there's a limited amount we can work with, but that may change depending upon what the contents of the pre-trial brief are. Thank you.
Thank you, Mr. Young. Mr. Bayezu, please.
Thank you, Your Honour. We agree with the submissions that have already been made by the other defense teams, and we support them. We are in the same position as the other defense teams as far as the progress of our investigations is going, and we stand by the submissions we outlined in our written submissions for the status conference, that is Filings 606. Thank you.
Thank you, Mr. Bayezu. Mr. Prosecutor, do you want to mention anything? Briefly, please.
Yes, Your Honour, very brief on one point. I will only note that the proposed framework for contacts with witnesses and handling of confidential information involves a careful balancing of the duties and prerogatives of the specialist prosecutor.
Mr. Prosecutor, sorry to interrupt, but this will be litigated in written ruling. So I mentioned this to the defense. I don't want the parties to start raising the merits of your request today, please.
Your Honor, all I then will do in a briefer way is put on the record that the submissions made by the Thaci defense mischaracterize the proposed framework as submitted by the SPO. Thank you.
Thank you, Mr. Prosecutor. Let me turn to the court officer because I see that there might be another issue with the VTC. Okay, I've been told that there is another interruption with the VTC and that it's been reconnecting. So we have to wait for a couple of seconds. So for the information of the public, we are currently reconnecting with the 4 accused. And I see now that we are reconnected. Can I, Madam Court Officer, can you confirm that the connection works for the 4 accused? Thank you, Madam Court Officer. We can now proceed with the next item in our agenda related to detention. And for this, I would like the registry to give an update on the detention regime, given the evolution of the COVID pandemic, including but not limited to counsel and family visitation policies. And if you can also address what has been mentioned by Mr. Kihu for the limits, that would be much appreciated. Mr. Roche, please.
Thank you very much, Your Honour. As regards the general situation, the activity schedule for detainees has been reintroduced following the necessary suspension for a period of time due to an outbreak of COVID, but now it is back to normal. In terms of visits, there are a certain number of restrictions, but family visits are allowed and are taking place at the moment. They're linked to members of the close family and other family members of detainees. As regards counsel visits, they are proceeding. They're proceeding very intensively. We, of course, consult on a weekly basis and formally and on a daily basis informally with the medical officer, and he provides advice about the necessary measures to ensure the safety of detainees and others who are present in the DMU. Just today, there was a recommendation, a strong recommendation, that the number of persons present in the meeting rooms be reduced because of the evolution of the pandemic. To respond to Mr. Kyo's comments, we have arranged and have been just now arranged visits for all of tomorrow, which will involve 2 team members and an interpreter physically present. Obviously, other team members can attend remotely. There's provision for some to attend remotely, some to be physically present, and Zoom and telephone consultations can happen in the evenings and, if necessary, at weekends through prior arrangement. So again, these measures are based on medical necessity. As soon as they are no longer deemed necessary, they will be removed. Thank you.
Thank you, Mr. Roche. Does any of the defense team want to comment on the registry submissions?
No,
Mr.
but Your Honor,
Key.
I'm sure you can appreciate how difficult this makes consultation with client and our ability to conduct a proper investigation with his assistance, which we, of course, need.
Thank you, Mr. Kihu. Let us now move to the date of the next status conference. I confirm to the parties that I intend to schedule the next status conference on Friday, 4 February 2022 at 14:30 Hague time. I invite the parties to confirm their availability. Mr. Prosecutor.
Your Honor, the SPO will be available on the 4th of February. Thank you.
Thank you, Mr. Prosecutor. Mr. Kihu?
Your Honor, we will be available. Thank you.
Thank you, Mr. Kihu. Mr. Emerson?
We will be available, Your Honor.
Thank you, Mr. Emerson. Mr. Young?
Yes, we'll be available. Thank you.
Thank you, Mr. Young. Mr. Beyezu?
We will also be available, Your Honor. Thank you.
Thank you, Mr. Beyezu. Mr. Laws, please.
Your Honor, yes, we'll be available. Thank you.
Thank you, Mr. Laws. You will receive a scaling order which will include an agenda before the status conference in due course. And as usual, I invite the parties to make written submissions if they would like to raise any specific issue during the next status conference. And I also remind the parties of the submissions that they are expected to file as we discussed earlier in this status conference. At this point, I would like to ask the parties and participants whether they have any other issue they would like to raise. Mr. Prosecutor.
Nothing further, Your Honor. Thank you.
Thank you, Mr. Prosecutor. Mr. Kihu.
Nothing that we haven't previously addressed. Thank you.
Thank you, Mr. Kihu. Mr. Emerson.
Nothing, Your Honor.
Thank you, Mr. Emerson. Mr. Young, please.
No, thank you.
Thank you, Mr. Young. Mr. Beyezu, please.
Thank you. Nothing from us.
Thank you, Mr. Beyezu. Mr. Laws, please.
Your Honor, there's nothing we wish to raise today. Thank you.
Thank you very much. And before we end this hearing, I will issue my third oral order on the defense request for reconsideration of my decision of 9 December 2021, in which I extended the word limit for the SPO's pretrial brief. I find that the defense has not demonstrated a clear error of reasoning or that reconsideration is necessary to avoid an injustice pursuant to Rule 79(1) of the rules. In relation to the size and complexity of the case and the volume of disclosure, the defense has not demonstrated an error in relying on this factor to determine whether an extension of the word limit would be warranted. The relevance of this factor to other matters does not diminish its relevance to whether an extension of word limit should be granted to the SPO in relation to its pretrial brief. The defense itself has stressed on a number of occasions the need to know the SPO's case and the evidence the SPO has in support thereof, as well as how essential the SPO's pretrial brief is to that endeavor. In this context, a detailed pretrial brief with extensive references to the evidence can do nothing but assist the defense in its preparations. As regards the finding that the SPO's request for an extension of the word limit was made sufficiently in advance, while the request could have been made earlier, a week before the deadline for filing the SPO's pretrial brief was sufficient time to consider the request. In addition, I note that the disclosure process remains ongoing. In particular, the Rule 1023 disclosure has been suspended at the request of the parties and will only regain momentum in the new year. In this context, the time needed to translate the SPO's pretrial brief will not be the sole determinative factor in relation to the length of the pretrial phase of the case. I therefore find that the test for reconsideration pursuant to Rule 79(1) has not been met. This concludes my third and last oral order. And this concludes today's hearing. I thank the parties and participants for their attendance. I also wish to thank the interpreters, stenographers, audiovisual technicians, and security personnel for their assistance. The hearing is adjourned. Thank you.
All rise.